My name is Casey Maddox. I'm Vice President for Legal and Judicial Strategy at Americans for Prosperity and Senior Fellow for Free Speech at Stand Together Trust. And on behalf of the Free Speech and Election Law Executive Committee at the Federalist Society, we're pleased to provide and welcome you to our panel here today on censorship by proxy. I'm very excited to hear this conversation. We've got a distinguished panel. So I'll introduce our moderator and let him get right to the rest of the introductions in the panel itself. Judge Gregory Katsas is a judge on the United States Court of Appeals for the District of Columbia Circuit. He's a former partner at Jones Day, Assistant Attorney General for the DOJ's Civil Division and Acting Associate Attorney General, and law clerk to the Supreme Court Justice Clarence Thomas, to name just a few of his previous roles. Judge Katsas was an executive editor on the Harvard Law Review during his tenure as a law student, and he's argued more than 75 appeals, including 3 in the Supreme Court, and is a member of the American Academy of Appellate Lawyers and the American Law Institute. So join me in welcoming Judge Katsas.
Thank you. The First Amendment forbids public officials from censoring disfavored speech and speakers. But what happens when officials enlist private parties to do the censorship? In recent years, officials have pressed social media platforms to silence dissenting views on everything ranging from political corruption to public health. Even worse, officials have pressured suppliers of essential and ordinary goods and services, ranging from insurance to banking, to drop clients engaged in unpopular or controversial speech. And there's no way to know how many private decisions to silence speech or speakers or to cancel customers or clients based on their speech have been influenced or coerced by the government. Is this inevitable in an age of unprecedented opportunity to reach large audiences? Should we have greater transparency when public officials wield their power to curb speech? What's the line between encouragement and coercion? And is it the right one to separate constitutional from unconstitutional censorship? Should Congress address public or private censorship? And if so, how exactly? We've got a great panel to address these issues. I'll introduce them briefly. Will Duffield is a policy analyst in the Cato Institute's Center for Representative Government. His research focuses on government regulation and private rules that govern American speech online. In 2022, he published the online piece, Jawboning Against Speech, How Government Bullying Shapes the Rules of Social Media. Allison Hayward is a former case manager with Facebook's Oversight Board. She previously served as a commissioner at the California Fair Political Practices Commission, board member at the Office of Congressional Ethics, chief of staff to FEC Commissioner Bradley Smith, and assistant professor of law at Scalia Law School. Who's next? Brian Haas is a staff attorney with the ACLU's Speech, Privacy, and Technology Project. He previously served as a staff attorney with the ACLU's Center for Liberty and as the ACLU's William J. Brennan First Amendment Fellow. Andrew Grossman is a partner at Baker and Hostetler, where he co-chairs the firm's appellate and major motions team. He's an adjunct scholar at the Cato Institute's Robert A. Levy Center for Constitutional Studies and has previously served as a fellow and policy analyst at the Heritage Foundation. And last but not least, Eric Jaffe is a partner at Shear Jaffe. He has extensive experience in appeals and has been involved in over 120 Supreme Court matters. Eric is a former clerk to Supreme Court Justice Clarence Thomas and to my colleague, Judge Doug Ginsburg on the DC Circuit. Will, you're up first.
Wonderful. So this panel concerns roundabout censorship or censorship by proxy. But how does this happen? There isn't a formal legal mechanism for it. Instead, government officials use informal demands and threats to coerce private actors to do what the state cannot. This practice is called jawboning. There are other words for it too: bullying, threatening, browbeating, demanding, cajoling. Regardless of the term used, making informal demands allows the government to slip its constitutional bonds. Jawboning was once used in attempts to control prices. And in response to resurgent inflation, some politicians are using it in the economic arena again. The term began as a sort of derisive reference to Samson's vengeance on the Philistines in the book of Judges, where he proclaims, "With the jawbone of an ass, I have slain 1,000 men." In the 1970s, President Carter was said to have slain 1,000 bankers with the jawbone of an ass. But over the past half-decade, jawboning has been increasingly used as a method of censorship. Last fall, I published a paper about jawboning titled "Jawboning Against Speech: How Government Bullying Shapes the Rules of Social Media," available online, or a couple copies right over there. In this research, what really concerned me most was how the scope of jawboning and the number of Congress members involved in the practice have grown. When I first started combing the congressional record for examples in 2018 or so, almost all of the government demands were narrowly focused around Russian election meddling. There's still issues with this. Platforms can't be expected to secure our elections. Americans do have a right to receive foreign speech, and cracking down on foreign disinformation means inevitably cracking down on some American speech that looks like foreign disinfo. But the scope was pretty limited. Then, however, jawboning sort of came home. Politicians on both sides of the aisle began making demands about domestic speech and speakers. Elected representatives seem to have become comfortable jawboning about almost everything: shock jocks, unfalsifiable bias, 3D printed guns, and even crass jokes posted by their constituents. Although my paper focuses on jawboning by members of Congress, it isn't limited to threats by legislators. These public threats are just much more visible than others. The Twitter files reporting and a lawsuit brought by Louisiana and Missouri against the Biden administration have given us a look at how government agencies and civil servants push platforms to suppress speech behind closed doors. However, I think a lot of the congressional jawboning sits upstream of, or is really entangled with, the administrative state bullying that has been revealed more recently. One of the chief ways platforms demonstrated that they were doing something in response to congressional demands was engaging with the intelligence community and later other executive branch agencies. Once platforms began accepting government requests, they were overwhelmed by them. Like user-submitted content, there were simply too many requests to properly vet each one. So why is this happening? The First Amendment prohibits government speech regulation. However, by bullying the social media platforms that speakers rely upon, government officials can suppress unwanted speech or interfere with platforms' editorial judgment. When the government presides over antitrust cases at the state and federal levels and doles out fiber optic subsidies, lucrative government contracts, and more, there will always be some lever that officials can threaten to pull. This circumvention should be seen as a sort of path-dependent response to the strong formal protections offered by the First Amendment. The internet dramatically lowered the cost of publishing, bringing a torrent of what Eugene Volokh deemed cheap speech in a prescient 1996 Yale Law Journal article. Not everyone was happy with this disruptive deluge of talk. In other countries, such as Turkey or Germany, demands to put the speech genie back in the bottle were met by new laws prohibiting unwanted speech and imposing censorship obligations on platforms. Jawboning about speech isn't a new problem, but when digital intermediaries are involved, government pressure is harder to detect and address. In Bantam Books v. Sullivan, the Supreme Court held that threats of government action can violate the First Amendment, whether or not they are carried out. In Carlin Communications v. Mountain States, the Ninth Circuit ordered the reinstatement of a phone sex line dropped by an Arizona phone company after it was threatened by a county prosecutor. In this analog context, it was easy to prove that the line had been disconnected and that the disconnection was prompted by the prosecutor's threats. A phone line is either active or it isn't, and phone companies don't regularly moderate content. On social media, however, more fine-grained algorithmic moderation can invisibly increase or decrease the visibility of particular speech, and platform content moderation is a constant, imperfect process. Here, jawboning is much harder to detect. Unfortunately, jawboning is simply a difficult problem to solve. Bullying by members of Congress is protected by the speech or debate clause. Identifying jawboned content moderation decisions is exceedingly difficult. Government demands often overlap with private platform rules. As a result, lawsuits over jawboning often fail for lack of a specific nexus between government demands and the platform's decision to remove some speech. And even when jawboning can be identified, it's hard for courts to correct it, say by ordering the reinstatement of a banned account or post, without trampling on platforms' editorial rights, too. However, the first step towards a solution is recognizing the problem, and I'm confident that today's discussion will help us to do so. There's also some room for disclosure of government communications with platforms to curb untoward requests and provide the missing link in later litigation. But I'll leave a fuller explanation of this solution to Andrew. Thanks.
Allison?
Yeah, okay. Greetings. I have some prepared remarks that I wrote on a plane with a little bit of turbulence yesterday, and I can't really read my writing. So I'm going to speak extemporaneously, which means if I leave something out or you don't follow the logic of what I'm saying, we'll be happy to clarify in the Q&A. I was the head of the case selection team at the Facebook Oversight Board, or the Meta Oversight Board as we now called ourselves, until about a month and a half ago. That organization, just real briefly, the Oversight Board was established by Meta about 3 years ago to take on significant and difficult content moderation questions. And it comprises a group of international free speech and human rights experts, as well as some American members. They serve in panels of 5. They take on cases selected by the Case Selection Committee, which I worked with most closely, in anywhere from 90 to 120 days after investigation and research and a lot of argument, will write an opinion about a particular content moderation decision. This is, as you can imagine, not the way content is typically moderated. In fact, it's quite different. Content on a large platform such as the ones that Meta has is done very quickly, and a lot of it is automated. So in a sense, the Oversight Board, while providing an interesting glimpse into how content moderation affects groups out in the real world and can answer some questions about how content moderation is done internally, is really not content moderation in any sort of realistic way. You cannot have this fully blown investigation and consideration of every content moderation decision, nor would you really want to. For one thing, the appeals that come to us after having exhausted the appeals within Facebook or Instagram. Those are the 2 platforms that we looked at. And so they've already been through one round of review, except that oftentimes that round of review is also automated. So if Facebook or Instagram is using a classifier that has been trained to flash on anything that looks like a swastika, and it flashes on a swastika type symbol outside the context of Nazism, like in a piece of indigenous Southwestern art, and the person objects, saying, I posted this is not violating the content moderation rules of the platform because it is not a swastika, it just looks like one. And the automatic classifier that looks at that again is trained to flash on swastikas and flashes on it again. And then they come to us with a, hello, obvious over-enforcement. Unfortunately, we only, at the Oversight Board, can maybe rule on at best 15, 20 pieces of content a year. Are we going to take the obvious over-enforcement of the swastika, or are we going to take a policy advisory opinion that Meta gives us regarding how they are dealing with COVID misinformation, which is, by the way, a policy advisory opinion that was published last week that took a long time and a lot of consideration to come up with, but deals most specifically today with our jawboning topic, because one of the things that came out of that question that was posed to the Oversight Board was the fact that there had been some governmental pressure to remove misinformation about COVID. In fact, you may recall the Biden administration's declarations that, well, of course, platforms should be removing COVID misinformation, and you know there's 12 sources for most of the information that is appearing on the platform, minimizing how difficult it would be to do this. Unfortunately, let's just take that for an example. So Facebook puts in its community standards that it will remove COVID misinformation, defines more or less what that is. You can read the community standards for yourself. Comes up with internally roughly 80 statements that it considers to be the kind of misinformation that needs to be removed from the platform to preserve public safety and keep people from doing harmful things to themselves, like drinking bleach and whatnot. And most of the statements, I think we would agree, would be misinformation. 5G networks do not give you COVID. Nonetheless, people would put that on the platform. They have a First Amendment protected right to say that in a public sphere. This is not a public sphere. Meta has the right to say this is not something that's acceptable for our platform and take it down. But when that's automated, you've got those 80 some odd statements. The automated classifiers don't have judgment, and you will end up with detectable over-enforcement and detectable under-enforcement. And that gets to sort of the message I would like to leave you with, if nothing else today, is whenever you as a legislator or you as a lawmaker or you as a judge or you as a concerned citizen want to tell a large platform to take down a particular kind of thing or leave up a particular kind of thing, it's not going to work in some small number of instances. That small percentage, however, is an enormous gross number when you're talking about hundreds of millions of photographs, for instance. Okay, if you're 99.9% effective, you've still got a significant number of illegal photographs or whatever it is on the platform, and there's really no way around that. Automation certainly is part of the lack of, complete enforcement. But at the end of the day, asking Facebook to remove all of the X on its platform or not remove all of the Y on its platform is a little like asking the Highway Patrol to find all the speeders and hold it liable if it misses one. So as a practical matter, I really want to caution that a lot of these content moderation decisions are inexact, will be sloppy. That's just the law of large numbers. That's how it is. So I'm not in favor of jawboning, personally. The Oversight Board, as far as I know, does not have an opinion about it, although in its recent COVID decision, it did ask Meta to consider being more transparent about governmental requests it does receive and does honor, I guess. But I think what we've got here is really a problem of envisioning how content moderation should work. I think a better way of looking at problems with either over-censorship or inappropriate content on platforms and enforcing against it is potentially to diversify and decentralize the work of the platform content moderator. In particular, Meta has adopted a very centralized philosophy where they've got global content rules. They are ideally enforced uniformly throughout the platform. There are exceptions to that because there are places where you can't say certain things about the King of Thailand, where there are other places like the US where you could. And so some of this stuff is geo-blocked, but for the most part, they profess to have global standards that are enforced even-handedly across the platform globally. This is unrealistic. And it's something where, again, the oversight board has said, do you really mean this? I mean, for example, in the COVID advisory opinion, the risks of disinformation or misinformation in certain geographies might be quite more profound than in others where you've got a more robust, independent, free press and the freedom to debate topics. If you've got a government in a country where a certain COVID philosophy is considered to be inappropriate, that's going to be a lot harder to work with. And so I think having that publicized is a huge step in the right direction. And then having the content moderation that's being done on the platform more like, I hesitate to use a specific example, but there are platforms that will devolve content moderation to administrators of particular groups. So you've got a situation where you've got a group that wants to talk about COVID, and you've got an administrator who's happy to tolerate some degree of argument about certain, COVID solutions, and in other parts of the platform where you've had administrators that maybe won't, and that's fine. The platform is otherwise complying with laws, but when it comes to jawboning, how much more difficult is it then for a member of Congress or the executive branch or the World Health Organization or whomever to interrogate the person who made that content moderation decision? It's really sexy to bring, Mark Zuckerberg before Congress. It's not that interesting to bring volunteer content moderator in Duluth who's working out of his basement over to Congress to explain why this is okay and this isn't. I think we all, as sort of small c conservatives, understand that smaller government tends to be better, tends to be more responsive, tends to be better able to do what we want and more responsive to criticism. And I think this is just another example of that. To the extent that the large platforms can get away from this centralized command and control kind of approach to content moderation into something that's a little more decentralized and a little more localized, jawboning becomes more difficult, and I think users get a better experience where their content moderation is more attuned to what their values are and why they joined the platform to begin with. And my time is way up, so I'm going to stop talking.
All right, Brian.
Thank you, Judge. It's a pleasure to be here speaking with you all. As Will mentioned, jawboning is not a problem that's unique to the age of social media. I believe it was an early 20th century Peruvian dictator who said, "For my friends, everything. For my enemies, the law." Courts have often struggled to determine when a government official's invocation of the regulatory authority is in essence an impermissible attempt to retaliate against or censor or chill protected expression. In Bantam Books versus Sullivan, which Will mentioned, you essentially had a state-created commission in Rhode Island that went around circulating letters to booksellers highlighting what they called objectionable material. And the commission just happened to mention that it had the authority to refer obscene books to the prosecutorial authorities in Rhode Island for the initiation of criminal proceedings. Sure enough, the booksellers got the message and hastily removed any books that were listed as objectionable by the commission, whether or not they were obscene. In defending the action before the Supreme Court, Rhode Island essentially said, we were just providing free legal advice. Fortunately, the Supreme Court rejected that argument. It said we must look past forms to the substance. And what's really going on here is you're trying to get these books pulled from the shelves, and that is a state action that falls within the meaning of the First Amendment, and we have to determine if that's a First Amendment violation. So since Bantam Books, courts have identified essentially 3 factors to help them assess in various different contexts, because this comes up in every conceivable context under the sun, whether a particular invocation of regulatory authority is coercive or is permissible government speech. They look at 3 factors. The first is the words and tone of the message, particularly if it references the regulatory authority of the official. Second, if the official has regulatory authority over the person to whom they're speaking. And third, how the message was perceived. In other words, did people fold up their tent, pull the books off the shelves, or not? None of these factors are dispositive, and they all have to be considered within the broader context, but those are the kinds of things the courts look to. I think in around 2015, in Backpage versus Dart, there was a prominent case addressing this issue. The sheriff of Cook County, Illinois, sent cease and desist letters on official sheriff letterhead to Visa and MasterCard regarding their financial relationships with Backpage. For those of you who might not be familiar, Backpage was essentially a competitor to Craigslist. It was an internet classifieds section, and it had many perfectly legitimate services advertised, and it had some services that were perhaps more controversial, some sex-related services, for example. The sheriff, in his letter to Visa and MasterCard, essentially said, by engaging in these commercial transactions with Backpage, you are facilitating unlawful sexual activities, prostitution, for example. And by the way, there is a federal money laundering statute. I, of course, don't enforce it. I'm merely the sheriff of Cook County. But you should designate someone to talk to me about this because I'd really like to follow up with you about these issues. Sure enough, a couple days after getting that letter, Visa and MasterCard terminated completely their relationships with Backpage, and the sheriff had a nice press conference where he announced that he was successful in convincing these financial institutions to terminate their relationships. Backpage sued Sheriff Dart, and on appeal in the Seventh Circuit, Judge Posner essentially held that the sheriff had engaged in unlawful job owning. Even though he did not have direct regulatory authority over Visa or MasterCard, of course, anybody would recognize that the sheriff of Cook County has friendly law enforcement contacts with the FBI. The sheriff made explicit reference to that in his letter, and the threat was adequately perceived by Visa and MasterCard. It came out actually in discovery. They had emails essentially saying, he's really got to tone it down. This looks a lot like blackmail. So in that case, Judge Posner essentially held this can't be allowed to continue. And in particular, what he highlighted is that when you have large institutions, financial institutions, social media platforms, the cost to them of silencing or terminating relationships with any individual speaker is going to be low, right? They've got thousands, if not millions of people that they provide services to. They also have extremely broad regulatory liabilities. And so getting on the wrong side of the sheriff of Cook County, or God forbid, the Department of Justice, it imposes much higher costs on the company than terminating relationships, especially with a controversial speaker like Backpage. And so Judge Posner said we have to be especially vigilant under these circumstances, where officials are potentially using that regulatory authority to distort the marketplace of ideas. The last case I'm going to talk about is a case that's actually currently pending on a cert petition before the Supreme Court. It's NRA versus Cuomo, and in the interest of full disclosure, I'll just say the ACLU filed an amicus brief in the district court here on behalf of the NRA. In this case, essentially what happened is, or as alleged, is that the superintendent of New York's Department of Financial Services, Maria Vullo, initiated investigations into the NRA's insurance providers and related financial institutions in November 2017. In February 2018, shortly after the Parkland shooting, Superintendent Vullo had, according to the NRA, backdoor conversations with a number of the financial institutions where she essentially told them that she would prefer if they no longer did business with the NRA at all. Shortly thereafter, in April 2018, Superintendent Vullo circulated a guidance to all regulated entities in the Department of Financial Services, advising them about the significant risks, and I quote here, including the reputational risks of associating with gun promotion organizations like the NRA. Shortly after that guidance letter was issued, actually the same day that guidance letter was issued, Governor Cuomo issued a press release talking about how he was taking on the NRA. A few weeks later, the Department of Financial Services entered into consent decrees with two of the NRA's main insurance providers, Lockton and Chubb, basically saying that they agreed that they had engaged in illegal activities in providing certain insurance services to the NRA, affiliate insurance services for the NRA's Carry Guard program, paying several $1 million in fines and promising not to provide any of those kinds of services to the NRA ever again. Around that time, many of the NRA's other insurance providers spontaneously dropped the organization, and one of them specifically said, we're worried that we will no longer have our license in New York if we continue operating with you. And at least one banker said in, I think, American Banker magazine, that it was extremely hard to tell from Superintendent Vullo's letter what the rules were for insurance providers going forward in New York State when it came to contracts with gun promotion organizations. So the NRA brought a lawsuit after it lost several of its insurance providers in federal court. Superintendent Vullo moved to dismiss. The district court denied that, but because this involved qualified immunity, it went up to the Second Circuit on interlocutory appeal. The Second Circuit reversed. It said that the NRA had failed to even allege a claim of retaliation or First Amendment censorship against Superintendent Vullo. But what it did is, I think, in contrast to what Judge Posner did in Backpage or what the Supreme Court did in Bantam Books, it separated out all the different actions that Superintendent Vullo took, and it looked at each of them individually. So first it looked at the guidance letter and said, well, the guidance letter talks about reputational risks, but of course banks do have to consider the reputational risks, and banks have to consider all sorts of risks. And Secretary Vullo did not mention any particular regulatory authority that she had over the institutions, even though the letter was directed specifically to the regulated entities. So we think that the guidance letter was not in and of itself coercive. Then it looked at the consent decrees and it said, well, the allegations here were that they broke New York State insurance laws. So it was perfectly permissible for Superintendent Vullo to enter into these consent decrees. And then it looked at all the insurance providers dropping the NRA. And it said, well, the Parkland shooting had just happened. NRA obviously bought itself a ton of bad publicity. So not that surprising that it would be losing insurance providers around this time. But by atomizing all those different things, the court failed to take a step back and see the forest instead of the trees, right? The fact of the matter is, the guidance letter was issued 2 weeks before those consent decrees were entered into. And several of the bankers who dropped the NRA from their insurance program specifically cited their concerns about the regulatory risk in New York State. And I think when you add all of those things together, the clear implication that comes away is at least the possibility that the NRA has a valid retaliation or First Amendment censorship claim. And at the very least, the NRA should be allowed to proceed to discovery in order to figure that out. Because obviously at the pleading stage, they have their hands tied behind their back. They don't have that much evidence available. The import of the Second Circuit's decision, if it's allowed to stand, I think, will essentially mean that it's impossible to prove these kinds of job-owning claims through circumstantial evidence. You won't even be able to get to the discovery stage. So the only way that you'll actually be able to get into court and have this First Amendment claim heard is if you have direct evidence of a threat. And of course, regulators, when they see decisions like the Second Circuit's, will know you don't have to make the threat explicit in the statement itself. You can have regulatory authority or regulatory actions that take place around the same time. And of course, regulated entities are extremely sensitive. They will get the message. So that's why I think it is important that the Supreme Court take up this case and reverse the Second Circuit.
Thanks. Andrew.
Thank you, Judge. And thanks to the Federalist Society and for all of you being here and being bright and chipper following lunch. I really enjoyed Brian's remarks. But at the same time, I think that cases like Bantam Books, Backpage, and NRA versus Vullo are kind of the exception rather than the rule in the world of jawboning. And the reason why is because, really for two reasons. One is that those cases involved, if not express overt coercion, then something pretty close to that. And second is because the parties that were targeted ultimately found out about it or knew about it directly. So much of what we talk about when we talk about jawboning involves cases, this sort of the tip of the iceberg, the cases where we actually know what the government is doing and what it's requesting of third parties. And to date, the policy responses that we've seen to this phenomenon really focus on that as the paradigmatic example of jawboning. And so the policy approaches they tend to take focus on attempting to define and prohibit this sort of censorship by proxy. What I'm going to argue is I think that approach is inadequate and ultimately unworkable. Now, of the policy approaches that we've seen proposed so far, you've got a continuum, sort of a range. On one end of that continuum is just the extension of existing First Amendment law to reach potentially more subtle forms of government coercion targeting speech. And I think that involves the kinds of cases that we've discussed so far. This sort of approach is reflected, for example, in some of the litigation that's currently ongoing involving government coercion or at least suggestions to social media networks. And then on the other end of the continuum, you've got legislative proposals that would ban any kind of encouragement or advocacy by government officials for private parties to censor a third party's speech. And then somewhere in the middle of the continuum, you've got proposals that would restrict or somehow regulate government officials' requests specifically made to social media networks. Now, I do agree that existing law is inadequate to deal with this problem, but I think that trying to address it through new prohibitions is basically impossible. Any prohibition that is workable in practice will be far too narrow to reach most instances of censorship by proxy. And any prohibition that's broad enough to cover the field will inevitably prove unworkable because it would sweep in all kinds of routine governmental activities. So I'm going to outline a different kind of approach that's based on transparency. But before I get to that, why don't we consider a few hypothetical situations that I think illustrate some of the complexities in this field. And I will note these are all loosely based on actual events. So 1, a senator's office sends Facebook a report by a government-funded NGO claiming that a parents group on Facebook that is organizing opposition to a school district's new history curriculum is actually part of a foreign influence campaign to stoke disagreement and distrust among Americans. Facebook responds by deleting the group and terminating the account of the group's founder, who, it turns out, is actually the parent of school-age children in the senator's state. Another example. The FDIC and the Office of the Comptroller of the Currency tell the executives of a bank that providing services to an organization that engages in controversial advocacy may present a reputational risk detrimental to the bank's overall safety and soundness. The bank terminates the organization's accounts, and then other banks refuse to do business with it. Third example. A journalist posts a tweet claiming that COVID vaccines cause schizophrenia based on a report of one person who developed schizophrenia after being injected. An FDA spokesperson issues a press release calling that claim false and irresponsible. In response, Twitter suspends the journalist's account. A final example. An FBI official asks a newspaper editor to hold off on publishing information about a vehicle that might have been used in a kidnapping while agents are working to track down the vehicle and rescue the victim. The editor does cut those details from the story before it's published. Now, I chose these examples not because they're typical of the mine run of cases, but because they illustrate some of the problems and shortcomings of prohibition-based approaches. I think there are four sort of problems with those sorts of approaches that are worth exploring. The first is that this isn't just about social media. Any regulated industry, in other words, basically any industry, can be a vector for censorship by proxy. A policy response that's limited to social media networks is going to miss some of the most egregious instances of censorship by proxy. Second, none of our examples here, these hypotheticals, none of them involve express and overt censorship. One thing that we learned from the Twitter files is that when the government targets private expression, it rarely, if ever, demands that anyone be silenced or punished for their speech. It merely suggests that. And the business that is on the receiving end of those friendly suggestions knows what to do. It is at least arguable that none of the government conduct in our examples here would rise to the level of a First Amendment violation. But the practical results of that conduct can be indistinguishable from outright government censorship. So any policy response that is limited to the First Amendment and First Amendment violations alone will likely be too narrow. At the same time, our examples also show that not every instance of government conduct that prompts a private party to suppress speech is necessarily problematic or blameworthy. Why shouldn't law enforcement ask the media to delay the release of details about a crime that could put the victim's life in danger? And why shouldn't the FDA respond to misleading claims about drug safety? And what if Facebook actually does want to know about foreign influence campaigns being conducted on the site, even if it turns out that, in the example we had, that the report was incorrect? It simply isn't workable to ban the government from publishing statements and reports that might prompt a third party to silence someone else's speech. And if the ban were limited to the government actually advocating for that result, then that would exclude many or most of the most egregious instances of censorship by proxy, like our example with the bank and reputational risk. As we said earlier, the government often doesn't expressly advocate for censorship, it merely implies it or suggests it. Fourth, and I think most important, one way that some of our examples, at least, are worse than outright government censorship is that the speaker whose rights are at issue has no way of knowing about the government's involvement. The public doesn't know either. And so the result can be, in some instances, a de facto censorship regime that operates completely in the shadows with no accountability whatsoever. And I think that gets to the heart of the matter, because we know that transparency and accountability do work in this space. When word leaked about DHS's proposed disinformation governance board, the result was public outrage, and the board was scrapped almost overnight. The Twitter files shed light on how government officials interact with social media networks, and their release led to congressional hearings and debunking of some of the reports of disinformation campaigns that had been made by the government and its collaborators. What we've seen is that part of the reason that government officials carry out these activities in the shadows is that they don't stand up to the light of public disclosure. Politically motivated campaigns targeting so-called disinformation are still, even in this day and age, an embarrassment, a disgrace, and a political liability. The people conducting them know that, and so they avoid operating in public. So my question is, why not eliminate that ability? As all of our examples showed, it is difficult or impossible to draw a clear line separating permissible persuasion by the government, whatever you might think that is, from blameworthy censorship by proxy. But a transparency regime doesn't have to cut so fine to get the job done. It can be overbroad because nothing's being prohibited. It doesn't take a position on whether any particular act by the government is right or wrong, only that the public and the people being targeted should know what the government is doing. And in broad strokes, here's how I think a transparency requirement might work. The main provision is that the government would publicly report any act that orders, demands, suggests, or encourages a service provider, any kind of service provider, to limit or terminate services to any person based on First Amendment protected speech or association. The reports would be subject to the same type of redactions that apply under FOIA, so as to protect things like national security information. And the reporting requirement would be centrally administered in the federal government, probably by the Office of Management and Budget or something like that, with a public website that promptly publishes each report. Now, to protect privacy, the public reports would redact the name or identifying information of any person who's been specifically targeted by the government. In other words, why compound the harm? But at the same time, that person would receive a personal notice from the government of the government's action. So individuals could decide for themselves whether or not they want to go public and identify themselves to the public. Finally, any government employee who violates the reporting requirement, either by making an incomplete report or by failing to report altogether, would be subject to penalties similar to those that prevail under the Hatch Act. In other words, employment consequences and potential civil fines. The statute of limitations for the Hatch Act, I will note, is 6 years, so you don't necessarily have the risk that a single administration could insulate its own employees' actions from accountability. Now, all of this could be accomplished through a very short piece of legislation. But my question is, why not just go ahead and do it tomorrow? Everything but the penalties could be implemented almost immediately by executive order if the administration wanted to and if it took this threat seriously. And I see no reason why the House and the Senate shouldn't add similar reporting requirements to their own rules. Now, of course, transparency isn't a panacea, but it is a far better fit to the problem than anything else that's been proposed. And if it turns out that transparency isn't getting the job done, then at least we'll know that we'll have evidence of what's going on, and we'll have the information that we need to create and craft more targeted policy responses that focus on particular agencies or particular types of governmental activities. My final question is, what could possibly be the objection to increased transparency in this area? If the government is wielding its powers wisely and it isn't abusing them, then officials should be eager to dispel concerns about abuses. And if some government officials are abusing their influence and power to censor Americans' protected speech, then this would be the way to smoke them out. Let them defend what they're doing on the merits, not by hiding in the shadows. Thank you.
Eric.
So I fear I'm here for the comic relief portion of this panel because everyone else has been so wonderfully balanced, and I'm going to go somewhere else, somewhere quite perpendicular. And I'll tell you where the conclusion is to start so that you can all gasp in shock, and then I'll try to get you there with me if I can. I think that most government speech is a First Amendment violation, and at a minimum should be subjected to First Amendment scrutiny, whatever form of scrutiny your current favorite is, whether it's text and history, whether it's balancing, I don't really care. Some form of First Amendment scrutiny. And I think that most of this jawboning stuff and most of these indirect efforts to punish speech or change speech are all manifestations in some sense of the broader question of the government either speaking or using some power it has to manipulate the content of the marketplace of ideas, to tilt the scales, even if it's not literally by restricting the speech in absolute, but suppressing it, boosting the opposing viewpoint, what have you. So ultimately, I'm going to say that the easiest conceptual solution, though perhaps one of the most difficult to implement, would be to say that the government, qua government, may not speak unless it is service of a particularly compelling interest or some constitutional duty, like publishing the laws. Of course it can do that. It's probably required to do that. But when the government has an opinion on something, my general view is no one cares. No one should care, I don't want to hear it, and they have no right to express their opinion other than through actual legislation. If they want to pass a law, by all means go ahead and do it. You want to run an ad campaign? Piss off. So that's the premise, and the question is, how do we get there? And we get there in a couple ways. First of all, we have to identify what government speech is. So government speech is speech by the government as an official entity. It is not speech necessarily by individuals who work for the government. And the simplest example of this would be candidates speaking in their capacity as candidates versus office holders. So when an office holder runs for office for re-election, they speak as a candidate and have to pay for that separately and have to do that separately, and that's their private speech. That is not government speech. So many people who work for the government, I think, could probably jawbone using their own money and not using their official accoutrements of office, and through restrictions very much like we have on campaign speech. You don't get to use your franking privilege to run your campaign, and I don't think you should get to use your franking privilege to harass speakers and other people to try to manipulate the marketplace of ideas. So start with that there's a line that when I say government speech, I don't mean any speech at all by someone who happens to work for the government. I just mean if HHS takes out an ad campaign and uses public dollars to run that ad campaign that says, go get a vaccine, vaccines are great, vaccines are wonderful. I actually wouldn't let them do that. I would leave that to the private sector. So that's one line. The second piece of the reasoning that to understand is three different First Amendment doctrines, two of which from the speech clause, one of which from the religious clauses. First is the unconstitutional conditions doctrine. I sort of feel like jawboning is a indirect version of an unconstitutional condition. Do this or else. And the or else may be something that the government is entirely entitled to do on neutral grounds. Do this or I won't give you a contract. We generally accept that as an unconstitutional condition. If you don't stop criticizing the governor, you will not get a contract to pave the roads. We would think that that's an unconstitutional condition. If you support my opponent, I will not give you a contract to pave the roads, haul the trash. So I think jawboning is implicitly that. If you don't stop talking about X or associating with Y, I will exercise my prosecutorial discretion to investigate you. Or I will exercise my bully pulpit power to put you on the front page of the Wall Street Journal every day for the next month so that your stock price plummets, right? Those are the unconstitutional issues. It's not that they may not have the power to do it, but they do it as a condition of restricting or manipulating speech. We would normally think of that in many instances as plainly a First Amendment violation. My suggestion is that is functionally applicable most of the time that the government speaks. The second thing I would say is the compelled support for speech doctrine, right? So we generally believe the government cannot compel you to speak, and it cannot compel you to support the speech of others. So you can't say, hi, you must give a bunch of money to the RNC, the DNC, pick your poison, doesn't matter. But the government couldn't say, you have to support this group with whom you disagree. I believe that the government is such a group when they speak. That I may be forced to support the government when they do things, when they pass substantive legislation to build a road, to have police, to have the army, whatever it is. But when they're speaking, my view is, unless it is constitutionally required speech like publishing the laws, most other speech, whether it's advocacy, whether it's informational, whether, when it's beyond the core function of the government, I would say is probably beyond the First Amendment power to make me support. The third example I would give, which sort of brings these together, is the Establishment Clause. I think there's an implied Establishment Clause in the Speech Clause, that just as the government can't take sides and pick and choose between religion or religion and non-religion, I don't think the government can take sides and pick and choose between viewpoints, between opinions, between things that are of public debate and dispute and free speech that are part of the marketplace of ideas. I know the Establishment Clause is not there, so for all you really strict textualists who say the fact that it's not there means I'm wrong, that may be, unless you're also willing to throw overboard the compelled speech doctrine. Because we think of the word freedom of speech as not merely the freedom to speak, but the freedom to not speak. And I think that, at the end of the day, is where the Establishment Clause piece of the First Amendment comes in the freedom, in the word freedom. So let's get some examples of this. Some examples of this would be obviously the straight up jawboning that we've talked about already, where the government is going out and saying, I think Facebook is doing terrible things, they're awful, they're terrible, they're promoting, CSAM materials, they're promoting COVID misinformation, they're promoting Russia, whatever it is, and Facebook takes a hit for that, even if the government never prosecutes them, though the threat of prosecution or the threat of investigation, the threat of very expensive government oversight is always lingering. Even if none of that happens, Facebook takes a hit in their stock prices. Because when you're on the cover of the Wall Street Journal for terrible things with government officials calling you terrible names, your stock goes down. That's just the way it works. I mean, anybody in this room who has come anywhere near a large publicly traded corporation understands that step one, get the heck off the front page. So they don't even have to do something official beyond the official statement that the government says you're a terrible company. The government says you're supporting terrorists. And there's already a penalty for that. Second option, supporting people who create blacklists, right? We've seen this in the news. The government pays for some nonprofit group to identify all those misinformation groups out there. As if that were a neutral thing, right? So the group you pick, of course, is hardly some neutral expert on who's the misinformation. You pick your friends, you pick the ones who already agree with you, and lo and behold, the Southern Leadership Poverty Commission, whatever. What are they called? I don't even know. They're some, the hate group, the hate group. The one that is the hate group that calls everyone else a hate group, that one. They basically say, hi, everyone we disagree with, you're a hate group. And everyone we agree with, no matter how hateful what you say is, you're good, you're fine, right? So the notion that the government then goes out and funds, not necessarily them, but other groups of that ilk, who then give you a rating on are you good, are you bad, are you misinformation, are you hateful, that in and of itself creates market consequences for those groups because no one wants to associate with somebody who's on the blacklist for XYZ group, right? It becomes the government interceding in the marketplace of ideas by putting a huge thumb on the scale. And I think that distorts the marketplace of ideas. Other examples would be, it seems to me, this is one that's just in the news, that just got granted actually, is government officials manipulating the comment section of their social media accounts. So, no, it's one thing if it's literally is truly a private account that has nothing to do with your job, right? But if it's, the real Donald Trump at whitehouse.gov or whatever it is, and he says, oh, the only people who talk on my account are people who agree with me, and everyone who disagrees with me, sorry. To me, that's manipulating the marketplace the way it is. And it's a condition of, commenting. Obviously, he doesn't have to allow comments at all, I would think. But, and of course, we see this all the time. I picked Donald because he's easy, but there are lots of other ones. There was a mayor and a city councilman, and et cetera, a school board that just got granted their cases just got granted. So the last thing I'd say is these examples crop up all the time. They crop up in the context of limited purpose public forums, which I think of as an unconstitutional condition to a public benefit when you start limiting them too much. They crop up when the government gets up there and just lambasts people. And rather than worrying about the symptom, which is, did they do it too much? Did they do it for bad reasons? Were they acting responsibly? Were they trying to give us information that really is good information so we don't mind so much? I would go to the disease. The disease is they shouldn't be talking at all. They should be doing the job of government, which is to regulate, and they shouldn't be talking at all, and except where it's absolutely necessary, or except where it survives First Amendment scrutiny. And the one good example, the one I liked of Andrews, was the FBI saying, please don't report the details of this ongoing manhunt for this car. I think that survives First Amendment scrutiny, even though that is about as classic a prior restraint. I would probably support them saying you can't, not merely requesting it, but commanding it if they thought somebody's life was in danger and would be threatened by the release of this information. That's sort of like troop movements. So, some speech restrictions actually make it. So, but putting that aside. I would say go for the disease, not the symptoms. I understand that it would be a sea change of how we think of government, but once we start thinking of the First Amendment speech clause as having an implied establishment clause, it puts these into much better context. And even if we take a less extreme version of it, it tells us sort of where to direct our ire and where to direct our restrictions at things that are ultimately aimed at shifting the marketplace in the way that the existing regime of government wants to shift it. And that, to me, has always been the problem at the end of the day with things like this.
All right, we'll give each of the panelists a chance to respond to any comments of their colleagues. We have run a little long, so I'm going to really ask you to keep it to about 2 minutes.
I'll be quick. I guess first on Backpage v. Dart, I think it's very notable that even after Judge Posner's decision, kind of excoriating the sheriff's actions, MasterCard and Visa never restored service to Backpage. And for years afterwards, they were bouncing around to different kind of fly-by-night credit card providers or payment processors. And so I think that illustrates the difficulty of really providing a lasting solution that doesn't trample the First Amendment or associative rights of other parties. Because yes, Sheriff Dart probably isn't doing this anymore. And yet, you think about the whole problem of jawboning across the country, that decision doesn't really fix things in any way, case, or form. And I just want to back Andrew's solution here. I really think that the transparency is the way to go, both because of its ability to, on the margins, discourage this kind of conduct. If you look at some of the emails that say Andy Slavitt was sending from his whitehouse.gov address using kind of mafioso language. The White House is considering our options about what to do here when Facebook won't remove things. If he knew that he was reporting that to his supervisor, I doubt he would ever have penned that email. There's some things that when we know, not even in a public sense, but just to our peers within our department, making more work for others, we won't engage in. And secondly, the big reason to support this approach, to me, is the way it fills in the gaps in current litigation against jawboning. If you look at cases that have failed, like American AAPS v. Schiff, a group of doctors suing Representative Schiff over his demands to remove more misinformation. Now, setting aside the speech or debate clause, which, this wasn't really likely going to succeed in any case, the doctors couldn't demonstrate any particular nexus between Schiff's demands and the removal of their speech. And they never got to the stage where they were looking beyond the kind of public communications. And again, when we've seen litigation around jawboning, that's the part of the puzzle that's missing. And it's exactly the piece that disclosure would provide if that potential litigant or plaintiff received information in the first place saying that the government had demanded the removal of his speech. Well, he's got that missing piece now. So to me, that really puts it over the top as a solution where even if you double secret prohibit the jawboning, if the litigant doesn't know about it, he can't sue in the first place. So,
Allison.
Yeah, just two quick thoughts. First, because the Backpage case was brought up, it reminded me that I should also call to attention, although I have not worked for other aspects of what they call the stack in tech. I've only worked, adjacent to a social media platform, but when you think about the service providers, the domain name registrants, the other payments providers that are all part of the ecosystem of tech communication, any part of that stack could be jawboned. And at the top, at the social media platform stage, at least I think it's a bit more visible, but certainly the fact that those parts of the stack are more obscure and harder to see the effects means, I think, then pivoting on to Andrew's transparency point, I will second what Will just said. I think that's a really interesting approach. I especially like the fact that the transparency disclosure burden is on the governmental pressure points rather than the private entities. There are obviously forced speech issues regarding forced transparency reports and whatnot. Professor Daphne Keller has got a article in draft right now about that I think is quite good. And if you're interested in forced speech and transparency, I would recommend it to you. I wish I could remember the name of it, but it's good. Anyway, that's all I have to say.
Okay, Brian.
To Will's point, absolutely. I think remedies are extremely hard in this context, and that's partly because I think deplatforming decisions writ large are often overdetermined. When you have a particularly controversial speaker, there are likely to be many different people who want that speaker deplatformed, both in the government, so you're dealing with various different governmental authorities that might want that, and in the private sector. So how do you, if you just have an injunction against the one person who wrote the letter, that's not necessarily going to remove the chill from the private service provider. I think in some senses, damages may be more effective here, both because they provide some degree of recompense. So even if Backpage is still having trouble getting advertisers, at least it's getting monetary recompense for that harm as opposed to just sort of being left to its own devices. And more importantly, I think it provides a deterrent effect that will go across the government rather than just being on the specific actor who screwed up this time, right? Other government officials will see that. They'll be aware if they try to do the exact same thing, there likely may be punitive damages or something like that on the table. And so it hopefully chokes that off at the source. I'm also a fan of Andrew's transparency proposal. The only complication I might add to it is that I also think some privacy protections are necessary perhaps on the government side as well, because when you're dealing with certain kinds of speech, whether it's like true threats of violence, revenge pornography, stuff like that, if the specific person asking that thing to be taken down is forced to publicly disclose to the nation that they've asked it to be taken down, it can exacerbate the privacy harms that are behind the underlying thing in the first place. And so I think it just would need to be designed with sensitivity in mind.
I agree entirely with Brian's privacy point. What I would envision would be, redaction of individually identifying information combined with a notification to the individual, who's at issue personally, and then that person can decide whether or not they want to go public. We have something similar if you consider like the interaction in some cases between FOIA versus the Privacy Act. And so that's sort of how I would envision that working. But what I'd really like to comment on is Eric's proposal, which I can't decide if it's insane or brilliant or both. I guess the hang-up I have is really from an originalist point of view, given, that the president, has a duty to provide the State of the Union, that and that generally it's been considered that the executive branch works sometimes quite closely with Congress in terms of providing commentary and advice and counsel on legislative matters. And as we know, from the case law addressing Congress's investigative ability in service of its legislative powers, it would seem to me that sort of would be an escape hatch that permits potentially any executive component to speak on potentially any factual matter that might be relevant to legislative activity, which is, everything.
Insane or brilliant?
I'm leaning towards insane, but that's okay. It won't be the first time I've been associated with that word. I'll backtrack real quickly. I do like Andrew's, as a second best alternative to just shutting the government up entirely. I think sort of transparency is the next best option. In particular, I would make them put all takedown requests, make those publicly rather than privately. It's not so much that you get to have the private email and at some later point in some report that nobody reads, you maybe somebody will figure it out. I would make them make the takedown request in a public place where the media can see it immediately, with the privacy concerns all accommodated, obviously for things that are individual. But when you say take that down because that's not true about COVID, you do need masks, you don't need masks, whatever the truth of the day is, I'd like to see them do that openly rather than have them do that privately. The one thing that struck me from Andrew's presentation was something he said at the end, permissible persuasion versus blameworthy censorship. And to my mind, no persuasion directed at the electorate is permissible, right? The government is not here to shape our views. We are here to shape the government's values and behaviors by electing them or not electing them accordingly. And so it struck me that that's exactly what I'm concerned with. As for the president and other executive branch officials talking to Congress, sure, I think they can do that up until the point where it becomes yes, I'm going to give you an all-day platform with government dollars to go talk to the nation and get them on board with your legislative agenda, which I think gets it backwards. Right? Once again, gets it backwards. The government shouldn't be telling me what their rules should be. I should be telling them what laws they should adopt. And if they really need somebody to talk about it, they should have a private person come in and express their views and have a private person come in and express their competing views rather than the false authority of a government, a figure. I understand that none of this is realistic. But if you think about it in why is the government manipulating the information environment of the country, perhaps it's a little easier to understand why that's as big a problem for the First Amendment as censorship.
So we just did a jawboning panel in which our panelists are 5-0 strongly against jawboning. Maybe I'm wondering, hearing all this, if we're sort of going after some pretty low-hanging fruit here. If you assume there are willing platforms who want to facilitate speech between willing speakers and willing listeners, and you assume the speech would be protected by the First Amendment if the government tried to prohibit it, and then the government does all this jawboning to stop the speech, well, that's really bad, sure. I wonder if there might be some more going on with the platforms. Saw a couple of articles. I'm not sure if these were in response to your piece, Will, but they came out shortly after. Rachel Bovard says big tech isn't a victim of jawboning, it's an eager collaborator. Another one, Joel Thayer, big tech companies welcome taking positions and input from the political party with which they most strongly identify ideologically. So my question is, how much of this platform censorship phenomenon is really driven by the government jawboning, and how much of it is driven by the priors of the platform? And if there's a second piece to it, what, if anything, should the government do to facilitate the speech against private infringement?
I think there the counterfactual is pretty easy, because all you have to do is look at the platform governance environment, the private rules utilized and enforced by these platforms prior to 2016-17, when Washington suddenly took an interest in online speech governance, not just in the domestic political sense, but a lot around ISIS, extremist speech all over the world. We went from an Arab Spring environment in which platforms' relatively hands-off moderation was celebrated in Washington, to one where Washington suddenly demanded that across the board they do more, and some jumped higher than others, I suppose. I think to Allison's point, decentralization is valuable, but there's always the danger of the government just moving one step up or down in the stack when a given intermediary or provider won't play ball. So we've seen a lot of that, but I don't think before we saw government pressure around this, we saw a lot of platform action around this.
Anybody else?
Yeah, I actually agree with you that a lot of times the quote-unquote censored entities will welcome it. It's cover, actually. It gives them cover, and they get to say, oh, it's not my choice that I'm dumping you off your platform. The government's telling me this, and I got to do it, so don't blame me. And it's reminiscent of Justice Kennedy's sort of defense of federalism, which is you need clear lines of accountability, and when you blur the lines between the states and the federal government, or here between the platforms and the government, nobody's accountable. So it's just one more reason why the government shouldn't be doing it at all. And when whatever the social media platform censors someone, they pay the price for that in the marketplace. Their users scream and yell and say, I got censored. And either people use them or they don't, or they move to another platform, or they stop watching CNN and stop watching Fox, whatever it is. There's a price to be paid for private censorship. People stop reading your newspaper. People stop using your platform.
I think one problem, though, is when you
And
have
if
consolidation.
folks want to start lining up, we'll go to Q&A, but go ahead.
Please. I think one of the problems though, is when you have consolidation in the media market, and in particular in the social media market, that option that Eric was mentioning of like, well, if this platform's got a bad content moderation policy, I'll just go to another platform. If there are really 3 platforms where all the debate is being had, you don't have that many options, and those 3 platforms are going to be especially sensitive to regulatory risk. And if there's not an opportunity for new platforms to arise, for new networks to build, then you're essentially left at the mercy of those 3 companies.
Those barriers to entry are very important, because so long as someone else could presumably come into the market to host the speech that you're being told to take down, the whole environment's much freer. It can go elsewhere, and you can say that back to the government.
Okay, let's take some questions.
Hi, John Vecchione with the New Civil Liberties Alliance, and I'm counsel in Missouri v. Biden. I'm counsel in the Changizi case, so I do have fixed views on these things. But one of the questions that came up while you were all discussing this is, how would you, with Andrew, with Mr. Grossman's proposal, it's oftentimes it looks to me like the platforms don't want to do this. There's a lot of government pressure, but the government pressure, unless it's somebody like Alex Berenson, isn't specific to a person. It's the sort of thing where, what we don't like? We don't like this sort of thing. And some of it can come from the White House press secretary. Some of it can come, and I do look forward to Cher Jaffe's case that press secretaries for the agencies are unconstitutional. But the fact of the matter is, what do you do about a general, we don't like this, that they message to these companies, and then someone in Congress says, oh, 230 is going to go. How do you do it at that general level that companies are sensitive to?
So I think you can create a reporting requirement that does sweep in those types of requests or suggestions or encouragements. And the key dividing line, at least as I would see it, would be anything that is, determining content with respect to the substance of that content or with respect to protected association. If that's the line, if that's what the government is asking a third party or a platform to do, then that's something that would be reported. Now, at the same time, you mentioned, say, statements by press secretaries, things like that. In a certain sense, that bothers me a little bit less. simply because those are public. The real problem we have right now is, we know what the tip of the iceberg looks like. We see when the press secretary says that, carrying this sort of content is irresponsible, and then we see how the social media networks respond to that. What we don't see are all the requests that are made in private, the emails, the text messages, the phone calls. And ultimately, if you're going to be dealing with, those sort of broad-based, suggestions or requests by the government, I don't really see how you handle that ultimately as a legal matter. Because if the government is saying, putting Eric's proposal aside, if the government is saying, we think this type of speech is irresponsible, and then a platform publisher says, you know what, we agree. It's hard for me to see in that, unless there's something else going on, what the state action is, and then how you would address that legally, and how you would ever distinguish that from a publisher making its own choices. At that point, you're really talking about regulating private platforms, and you're not talking about, the government's involvement in it one way or the other.
Okay, next.
Hi, I'm Cindy Crawford from Americans for Prosperity Foundation. I actually have two questions, but they're relatively short. The first one is testing Mr. Jaffe's theory. How would you handle interactions between people in representative functions and their constituents? And I'm not talking specifically in the social media platform, but just old school, like town hall. They get in there and they start talking about things, government speech or not government speech. And then my second question, it goes to Mr. Grossman and the panel, relating to the transparency proposal. Providing notice to people who've been censored by the government sounds great for people like us who could use that as evidence for litigation or for calling people out in public. But for the average person to receive notice from the government saying, hey, you've been censored for X, that sounds to me like a recipe for chill. And I just wanted to see if there were thoughts on that topic.
So the quick answer to the town hall is, if it's I'm going out on a listening tour, then I don't see that being a problem. If it's I'm going out on an advocacy tour to try to persuade my constituents to back some policy that I'd like to enact, I have a big problem with that, unless they do it on their own dime, and then they're acting like a candidate more than they are like an official representative of the government, and then that's fine, just make them pay for it. That would be private speech in that instance as opposed to government speech. But if they took the government flight to go on a around the country tour to drum up support for Obamacare, whatever it is, whatever, build a wall, I don't care. Yeah, that's government speech in my book.
On your second question, I think you raised a very good point. If you look at it from the point of view of somebody who is a victim of a government request like this, they'll already have some indication that something has happened because presumably their post has been removed by social media, or they've been dropped by their bank, or an account that they've had has been canceled. So they've already suffered some kind of consequence. And I think what the notification would provide to them is some indicia that there's more going on in the background. But I certainly take your point that, for somebody to receive something like that out of the blue might be a little bit surprising. I wonder, though, that ultimately that sort of surprise and the incredulity that may follow ultimately may be a laudable thing.
Okay, next. Go ahead, Alita.
Sure. So I just had a question about the nature of the problem, whether it's limited to the role that the government plays, or whether we have a more general concern about the censorship dynamic that seems to have a fairly sort of wide buy-in across public and private actors. And even just focusing on the role that the government plays, if it's a particularly challenging task to address the dynamic of jawboning, like how much do we care about the interests of, say, banks in deplatforming clients for ideological reasons? Like, is that the cleaner angle at the problem?
I'm not sure that it's cleaner. I think it's much more difficult. We've always had an aversion in this country to government censorship. And it strikes me that that's a very different problem than what you might call private censorship. The two are subject, in terms of regulation, to very different types of legal restraints. The First Amendment in the private space potentially cuts both ways, depending on how you characterize the services being provided. Yes, I think a lot of people do think that, that there is a problem with, private platforms and social media networks and financial service providers cutting off services to people based on speech or advocacy or things of that nature. But it just strikes me that it is so dissimilar a problem that it may not be productive to think about the two of them and to try and address them in tandem. At least that's my thought.
Just one quick idea on the notion of private censorship. Except in some very rare circumstances of things that I would think of as true public utilities. I think that's called free association. It drives me crazy when people talk about cancel culture, and I'm thinking that's free association. That's actually the consequence of being I hesitate to say the word, but being an asshole. If you're an asshole, people don't want to associate with you. Surprise, surprise, that's free association. And if companies don't want to associate with you, that's okay, particularly if they're expressive companies. If it's a bank, if it's the telephone company, I have a different problem. I view those more like utilities. But if it's a social media company, I actually view that more like a collective magazine or a letters to the editor space or something like that. I don't view them as utilities.
If you don't like Twitter, just move to Parler?
Yes, precisely.
Blue Sky's great.
Or create your own. Or get a website. Right? Just because you don't reach the audience you wish you could reach doesn't mean your rights have been violated. It just means no one wants to listen to you.
Can I just also add, when I first started at the Oversight Board, I heard a lot about how, inevitable the domination of Facebook was, and how, it was a public utility, because clearly there was something going on market-wise that preferred a concentration of power in social media. And I don't know about you guys. I live in California, and I know what's been happening with the firing of vast numbers of people who used to work on these social media platforms. I do not think that the dominance of Facebook is anything at all inevitable, and I don't think Facebook thinks so either. And as for just a quick addition to sort of private bias, certainly individuals who work at these platforms may be more to the political view of your recent graduate from Stanford University than somebody like me, who's an old graduate of Stanford University. But still, when those standards are actually implemented, they are implemented largely automatically, which is the message I wanted to give you guys at all, and without overt bias, it just is sloppy and very messy. We got a lot of criticism from not finding good that quintessential conservative that's been canceled by Facebook. And why don't you take a case involving a U.S. conservative that's been silenced? It's because all the conservative content we saw also involved other violations of the community standards. To wit, conservatives like to drop the F-bomb a lot. And we're not going to take a case where we consider asking Facebook to restore content that's got a lot of F-bombs in it. It's just not something we were going to do. And so there's other sort of social aspects that involve ordinary people doing the things that ordinary people do, unfortunately.
That probably explains why I'm not on Facebook, by the way.
Next, in the front.
My name's Jack. I'm the president of the FedSoc chapter at the University of Maryland undergrad. My question is for you, Mr. Grossman. When it comes to that Facebook anti-school board group getting suspended, do you think there's any situation where that nonprofit or government investigation could reveal a certain level of proof that this group really is a front for the Russians that would justify any kind of communication with Facebook to take some kind of action with that page?
Well, I think you put your finger on the problem, which is Facebook might really want to know if there is, some type of foreign influence campaign going on in its site. And, again, outside of Eric's point of view, if the government has that information, Facebook wants it. Facebook has a right to receive it if the government wants to offer it to them. And I don't necessarily see any inherent problem with that. The policy intervention that I would propose is simply that group and or the person who founded that group, whoever is associated with it, just receive some notification that that's actually what went down. And so if they wanted to then contact Facebook and say the government said this, that I'm a foreign agent, I'm actually the mother of 2 school-age children in Ohio, and here I am, they would have the opportunity to do that. Or if they wanted to publicize that the government was telling lies about them, possibly as a result of their own, their own advocacy with respect to educational policy, they would have that opportunity. So I wouldn't try to regulate the government sharing the information. I would try to make sure that it's really just open to the light of day so that people can respond to it appropriately.
I would just say real quickly that in a serious version of this where the CIA found, Russian bots manipulating stuff, that might actually survive a First Amendment test. I didn't say everything was forbidden. I just said it had to be scrutinized. So that might make it.
And the more public all of it is, the more that's disclosed, the more Facebook can make a kind of open, honest decision about the right level of credulity to bring or apply to these government claims, because sometimes we see the government get things wrong or overstate its case as to who's connected to the Russians. But the more that claim can be made in public rather than in private, the more it can be checked and vetted.
In the back.
Hello, I'm Matthew. I'm also with the undergrad chapter of FedSoc at the University of Maryland. I have a question for Mr. Is it Jaff?
Jaffe.
Jaff. So you mentioned that you viewed social media sites as a free association issue and compared them to like letters to the editor at a magazine. Magazines have their publishers, so they have liability for that. Section 230 obviously grants immunity to social media sites. Do you think that that comes into play in this issue at all and how you view the analysis?
Absolutely. But Section 230 doesn't define the First Amendment. So you can debate the policy value of Section 230 providing additional immunity beyond what is required by the First Amendment. But I don't think giving that immunity is ever an excuse to then back away from the First Amendment in a way that wouldn't otherwise be permissible. And I think back to the cases that tried to restrict corporate speech. First National Bank of Boston versus Bellotti, which said, it's a privilege to be a corporation, so we can tell you what to do whenever we want. And this is like, we gave you 230, so now we can tell you what to do whenever we want. That doesn't work for me. So it's not that 230 is required by the First Amendment, it's a policy choice. I happen to think it's a good one, but I don't think it's an inevitable one and certainly not a First Amendment required one.
Okay, thank you.
I would add that 230 doesn't just apply to some set of platforms or big tech. It's really quite universal. If you or I are operating a website, if you or I retweet things, then we are protected by Section 230. And so I think that breadth cuts against it being viewed as some special privilege.
Okay, thank you.
A couple of minutes left, so I'm going to ask the last question, which is, so Allison, you mentioned a couple things on the Facebook criteria. One is some criteria that probably everyone in the room would agree are fine, right? That they're going to be concerned if people say that you drink a gallon of bleach, that'll cure COVID. And then there are other, the issue of you have a good criterion and it's hard to apply perfectly, but has there been any recognition or concern that it seems like some of the other criteria that have been used by the platforms over the last couple of years have been a lot more problematic? And I mean, the one that's sticking in my mind is if we're talking about COVID, is the proposition that the virus might have originated in the Wuhan lab, and people were canceled left and right for suggesting that, and now it seems to be obviously a matter of huge public interest, and now it seems to be something that government officials are taking quite seriously.
Yes, there are definitely community standards and interpretations of community standards that I think would pass pretty much anyone's test, and ones that are not as well or have not stood the test of time as well. On that particular point, I think, as I understand it, and this was outside of my jurisdiction, but as I understand it from working with the material, there were 80 statements that Meta vetted with experts that they decided were misinformation and needed to come down. I was emphasizing more how sloppy that is in practice, but assuming that the statement that COVID began in a lab was one of those statements, what Meta says is that, well, we went to outside experts to set these. So to the extent that they're wrong, there's somebody else out there that really maybe is more blameworthy than we are. And I don't know what to do with that, frankly. I mean, I don't know if you really want the young Stanford graduates to be sitting around all by themselves, figuring out what the 80 statements are, or if you want them to go to people they think are experts, or you want me to choose who the experts are. There's going to be some problem anytime somebody sets up a list of 80 things you cannot say in any context. I think that, again, I prefer a content moderation regime that is more decentralized, so that you can have a page where you've got the young Stanford graduates coming up with the 80 unacceptable things, and you've got a group over here that wants to talk about the Wuhan lab. And the administrators of those particular subunits of the platform are held to whatever their participants want to see. They will have legal restrictions on what they can post. They probably shouldn't post terrorist content. They definitely shouldn't post child sexual assault material. They probably shouldn't human trafficking. You think of all the really ugly stuff. There's going to be somebody at the platform level saying, not that. But within that, with the things that we can tolerate as First Amendment protected speech, and where intelligent minds might disagree, I think decentralization is a great way of getting at that problem. I mean, we were conferring notes a little bit. It might look a little like Reddit. I don't know if any of you use Reddit, but Reddit, you join a subreddit, and there's administrators of that subreddit that largely set the rules, limited, again, by law, of what's said on that subreddit. So if you've got a subreddit that hates the band Journey, all kinds of hate speech related to the band Journey can participate on that subreddit. And Reddit, as an overarching platform, they don't care. You can have subreddits that talk about the use of illegal pharmaceuticals. That's something that Facebook doesn't want. But it's protected First Amendment speech, and you've got an administrator that's making sure that while you're talking about the illegal drugs, you're not dissing the band Journey, and everyone's fine. They're just little subunits, and I think, in general, I know I'm repeating myself at this point, but I think that's a better approach.
We are out of time, so
Sorry.
please joining me in thanking our panel for a fine presentation.
He had something to say, and I...